The broadcast is now starting. All attendees are in listen-only mode.
Good day, everyone. MBA Women International is pleased to present this webinar entitled Trademarks, Copyrights, and Trade Secrets. My name is Hannah. I'll be your moderator for this session. Please note that today's call is being recorded and all participant lines will be muted during this broadcast. If you need assistance at any time today, please email us at webinars@mbawomen.org. This session will last 60 minutes and include a question and answer period at the end. However, feel free to pose a question at any time during today's presentation. You may enter a question by simply typing it into the question box on your control panel and then clicking the send button. These instructions will be repeated later in the program. At this point, I would like to introduce today's speaker. As CEO of My Corporation Business Services, Inc., Deborah Sweeney is an advocate for protecting personal and business assets for business owners and entrepreneurs. With her experience in the fields of corporate and intellectual property law, Deborah has evolved from lawyer to business owner. She has extensive experience in the startup and entrepreneurial industry. She has been involved in the formation of hundreds of thousands of businesses for mycorporation.com customers. Ms. Sweeney received her JD and MBA degrees from Pepperdine University. She is active in the community and loves working with students and aspiring entrepreneurs. She serves on the Board of Regents at California Lutheran University and is a founding member of Partners of Pepperdine. Deborah has served as an adjunct professor at the University of West Los Angeles and San Fernando School of Law in the areas of corporate and intellectual property law. Ms. Sweeney is also well recognized for her written work online as a contributing writer with top business and entrepreneurial blogging sites. She is a regular contributor on Forbes, American Express, She Takes on the World, YFF Magazine, Empower Me Magazine, and Business Insider, among many others. And now, it is my pleasure to introduce to you Deborah Sweeney. Welcome to the program.
Hi, Hannah. Thanks for having me.
We're glad to have you.
My pleasure. Hi, everybody. So I just want to do a quick summary of our discussion. I think we're going to do about 20 to 25 minutes of overview of the topics of trademarks, copyrights, and trade secrets. And then I'm going to open it up for questions. I find that sometimes people learn the most from other people's questions. So please don't hesitate in the interim while I'm talking to put in questions in the chat box. And if I can answer them related to kind of the topics that we're talking about at that point, I'm happy to do that. So here we go, on to the next screen. So I probably got a lot of information about me during that intro. It was pretty detailed, but I think key highlights are kind of my experience with intellectual property and corporate law, practicing as a partner in a law firm, and then ultimately going in-house to a business environment. So I think I have both the legal experience but also the business experience and how it applies on both ends. And curiously, in my business, my corporation, we actually do a lot of incorporation and online filings relative to trademarks, copyrights, and related services. So going over at a high level, trademarks. A trademark is a word, a phrase, a symbol, or design that identifies or distinguishes the source of goods. And I think the big important piece here is that trademarks are related to the word itself associated with a product or service. So a trademark does not exist, for example, for all products and services if it's one particular word. It only exists as it relates to that product or service. And that can be compared with a copyright or patent. And a copyright is related really to content, whether it's a movie or a book or any type of writing or literary work that's an original artistic or literary work. Look at each one of those items. When we talk about what businesses need and why they need a trademark, the big reasons at a high level are that a business wants to protect its identity, and especially as it relates to going onto the web, because a bricks and mortar business that's at a local store in your neighborhood is known to those local people and they have a brand and it exists and there can be trademarks associated with it. But the interesting thing is that when it goes on the web, it's nationwide. And so you're trying to identify your business and your brand on a broad-based level at the outset. And so it's important to make sure that you're not just, when you're broader and on the internet, for example, you're not just thinking about local stores and comparing your brand to other brands that are really nearby, but you're actually having to think on a more national and, as you all know, international level. You also want to worry about the use of your mark by infringers and compare it. Contrastingly, you have to look at whether or not you may actually be infringing on a third-party mark. One of the most common things I've heard in my practice of law is that you have a name and you find it to be extremely original and unique as it relates to your goods and services, but you don't know if there's anyone else out there that has that same name, brand name, or trademark. And so you need to be able to ensure that not only are you filing a registration for your trademark so that others won't use it, but that in fact there are no prior users of the name that you're not aware of. The other important thing when you think about a trademark is making sure that when you file, you're sort of now claiming nationwide use of a logo or a phrase or a word mark, and I'll define the differences between those in a second. But you are making use of that mark on a nationwide level, and so as it relates to the internet, you're actually claiming that you have rights throughout all of the U.S. to use that mark. Trademarks often are considered the life of a business. Really, many times when people in today's day and age are selling businesses or getting new consumers, they are basing it on the brand and the name of their business. Unless there's an entirely new or novel product, service, or offering, like Facebook's offering, for example, was new and novel and there weren't a lot of competitors in the market, then the business itself is unique. But generally, the business, there are others that are doing similar business or services, but what makes the importance of your business is the actual brand name. So, for example, with Google, there are lots of search engines out there, but Google has been unique in that it's made a name for itself. The same holds true with Starbucks. There are many coffee stores out there, and unfortunately, there's probably less now because of Starbucks, but curiously, what has made Starbucks unique is the brand and the branding that's associated with it, and so it's built a name for itself. And really, one of the most important features of Starbucks is its brand name and the association of the product and service that we have as consumers. And you can see all of these brands beneath on the bottom of my slide, and they all probably immediately develop a connotation with them for us as consumers, or maybe even as employees at one point. And so those all relate and have been trademarks that have built big brands associated with them. And I'm sure as we enter into business or we try to grow our brands, one of the big things we think about is how do we get more consumers to associate a particular product with our brand, and how do we build that? And one of the biggest starting points is establishing trademark rights. So now looking at the benefits of searching before your trademark application, and one of the things that I mentioned earlier on is the fact that when you are establishing a trademark, you are doing so because you want to claim a monopoly in that word associated with the services. But we also want to make sure that someone else doesn't already have a claim, and so you want to do a trademark search. And usually you can do a professional search. My company, for example, offers a professional search, but you can also do a web-based search. Google is a great source to get started for searching for trademarks and whether or not your mark may or may not conflict with a third party. But the part that's critically important is that you make sure that your name isn't already being used by a third party before you invest in the time and the money of your trademark. What I often hear questions about are whether or not you should file for trademark protection before you actually go to market with your brand. The reality is that you can file what's called an intent to use trademark application, and that type of application says that you are anticipating going into business with a particular brand, but ultimately, in order to have full registration, you have to be using the mark and file an in-use statement with the U.S. Patent and Trademark Office saying that you're actually using the mark in commerce. So as an advisor, I typically say if you intend to use a particular brand, you should do a search and make sure that it's available first. And if you intend to use it, go ahead and get that intent to use application on file with the U.S. Patent and Trademark Office. But then, once you're using it, or if you've waited and used it first, then make sure that you update with an in-use application to give notice to everybody that you're actually using the mark in commerce and that you're now claiming national rights. You also have to make sure that you monitor your trademark use and ensure that third parties who may in fact be using the mark, that you're policing them. One of the obligations of a trademark owner is that you actually, if you were to find an infringer, you actually give notice and try to stop them. Obviously, sometimes for smaller businesses, it can be a relatively expensive endeavor to file a lawsuit, but certainly actions in the direction of protecting your trademark and your rights to that trademark are important in maintaining the ongoing viability of your trademark. You can see in this picture here what people are looking at when they're looking at potential of your mark conflicting with others, which tends to be something that someone looks at before they file for a trademark to make sure that their mark is available. But also, if there's a third-party infringer, you look at a couple different things. The first thing is you're looking at the trademark itself, the actual word. So if we take, for example, McDonald's, that would go in the trademarks circle, the word McDonald's. And then you look at the markets, and really the McDonald's that we all know fairly well is the McDonald's that sells hamburgers and fries. So as it relates to those goods and services, you're looking at the overlap here of McDonald's with the trademark here, and then the market of hamburgers and French fries, for example. And you're looking at the goods and services and where they sell. And here is the small little circle called likelihood of confusion. There may be other trademarks that exist out here that are named McDonald's but actually don't sell burgers and fries. And there may be other trademarks here that are named McDonald's, but they're not selling to the same consumers. And so you're looking really at where is the overlap, and that's where you define a potential trademark infringement. So when you're looking to start a new business, you're looking at another mark, usually a very similar or the exact same mark in a similar industry and similar market with similar goods and services. And there you can create confusion, and the big issue is you do not want consumers to relate one person's trademark in goods and services with another, because the whole point of establishing a trademark is having a monopoly to that brand name. One of the most common questions I get is the interrelationship between a business name and a trademark. So many people, when they file to incorporate or form an LLC, pick a business name. It's very common that a business name is the same as the trademark or brand name that a business is using. But it does not mean that when you get a corporate name at the state level with your local Secretary of State or the Secretary of State in your state, that means that you have protection as a trademark. It's quite common for business owners to start a business and open it and call themselves, for example, ours is My Corporation Business Services, Inc. But it doesn't necessarily mean that we have a trademark to the name My Corporation or My Corporation Business Services. So our next step after incorporating was to go ahead and register for a trademark on a national level as it relates to the services that we provide. So I think it's very important to know that if your business is incorporated and when you're incorporating, that you consider both aspects, the trademark search and making sure your business name is available, and that even if you're using the two names interchangeably, you're using your business name as a trademark, then you need to be aware that you should be thinking about both as both interdependent but independent considerations for your business. The next thing that people often think is whether their domain name is necessarily the same as the trademark. So I hear a lot of people suggest that if they own the .com version of a trademark, that means that they are a trademark holder. And you have what's called common law rights, meaning you've used it in commerce, but you really don't have much right of protection associated with the trademark by either getting the corporate name or by getting the domain name. Trademarks at the U.S. Patent and Trademark Office are really distinct in that way, and you need to file for protection in order to make sure that you're covered. So while they can be used as one and the same, a domain name can be the same as your trademark. It doesn't necessarily mean that if you own a domain name that you have the rights to protect it on a national level. And one common question that I receive when filing for trademark protection is whether or not to include a .com in your name for your trademark. More often than not, the U.S. Patent and Trademark Office disclaims or disavows, for lack of a better term, the .com portion. So, for example, for my corporation, they would look at my corporation and they would ignore the .com as part of it. Interestingly, it's a little anecdote. Years ago when .com was unique, people would file for names with .com, and the U.S. Patent and Trademark Office was giving trademarks associated with it before they sort of realized that actually .com was not really relevant. It was just a designator of where someone could find that mark, and it was on the Internet. But originally, when the Internet was unique and novel, the .com in and of itself often made a business name like mycorporation.com unique. So I think that's interesting to note. But nowadays, because .com is really so universal, there is no uniqueness in and of itself to the .com portion of a trademark. So is registration of the LLC or corporation with the Secretary of State sufficient to protect a name? And I think that's one other way of looking at the fact that they're not one and the same. A trademark is different from a corporation or LLC name. When we're talking about the trademarks for business owners, the benefits of a federal registration are important to think about. The first thing is that you have nationwide protection. You have the right to bring legal actions against third parties, and you have protection on the Internet. And when you're on the Internet, really, and throughout the U.S., your brand is king. And so it's very important, or queen, that you focus on development of that brand and establishment of your brand and registration so that you're ensuring that third parties don't use it. The types of trademark applications I mentioned earlier on, one is called an intent to use, and that's when you're looking to use the mark in commerce, but you haven't yet used it, and you want to get your trademark application on file. And the other one is an in-use application, which actually demonstrates that you're using the mark in commerce and you have a right to active registration. The process is not super simple. The application process, the application itself is not complicated. Once you get it on file, you usually wait about 3 to 4 months to hear back from the U.S. Patent and Trademark Office examiner, at which point the examiner will tell you that the mark is clean and can be registered, or they have questions of clarification. Either they think that there's a mark that might conflict with your mark, or that they think that your mark may be too descriptive of the goods and services, or even generic. And one of the important things to think about is that the strongest trademarks are those that are arbitrary or fanciful. So for example, a trademark like Google is a completely unique name, really, as it relates to online search services. So when you're coming up with something very arbitrary, you're a lot more likely to have an easier time getting it registered than if you're coming up with something like searchonline.com for an online search service. At that point, the USPTO would say, well, we're not willing to grant you a monopoly to 2 words, search online, that actually relate to exactly what you do and preclude other people from using that to describe their goods and services. So there's really a balance of creating a unique trademark and making sure that your customers understand what you do associated with your trademark. Many people want to create a trademark like Bob's Auto to describe that they do auto services. And the owner's name is Bob. But the reality is that the U.S. Patent and Trademark Office is going to say, well, we can't grant you exclusive rights to the word auto for auto services because there's lots of other businesses that have that name. So if Bob came up with a very unique name for his auto service, then he would be a lot more likely to get an actual registration on the mark. The other thing that people ask a lot about is whether a mark is registered once it's actually filed. And the filing of a trademark in and of itself is not the registration. I mentioned the whole process. The examiner evaluates the application and then ultimately sends communication traditionally relating to the mark to the applicant. And so there is no official registration until the mark is examined by the examiner, and then it's published in what's called the Official Gazette, which is a U.S. Patent and Trademark Office publication that gives notice to anyone who might have an opposition to your registration of the trademark. And then 30 days go by where it's published, where they allow for opposition time, and then ultimately, assuming all things go well, then it can be registered. In the meantime, when you are using the mark in commerce, you are always allowed, even without registration, to put the little TM notice in the top right-hand corner. That puts people on notice that you're claiming trademark registration, trademark ownership. It's called common law trademark. But once you have a registration, that's that heightened level of protection, then you put the R with the circle around it, and that allows you to take legal action against potential infringers. Okay, this page looks ominous because it has lots of words on it, but the reality is that it's really a description of what a copyright is and what it does. A copyright is an original work of authorship, and I mentioned earlier on that it can include literary, dramatic, musical, artistic, architectural, and other intellectual works. So what happens with a copyright is that you register. A good example of a copyright that we would all use is content for articles or publications that we do. Even websites have their own copyrights associated with them. And sometimes if there's risk of third parties taking the content from your website, you would register your website for a copyright protection. And the way you do it is you file a document with the U.S. Copyright Office, and traditionally, the act of filing is often sufficient with your documentation to support a copyright registration. It does not go through the analysis that a federal trademark goes through. So there is no real examiner other than a documenter to document that you filed your copyright and to hold it at the U.S. Copyright Office on file. Basically, when you file your copyright, and if someone else were to infringe, you can demonstrate that you have it on file and that you are the original owner of the work and claim damages. So if someone has infringed or used it, you can actually get monetary damages for each infringement. Without the copyright application or documentation on file, you can't get those damages. When we talk about a web page and copyright and trademark infringement, one of the important things to notice is the unique underlying design of a web page and its contents are all copyrightable. So we talk about the links, the graphic text, the website that's compiled, any unique elements that make up the original nature of the material. There's a lot of copying going on the internet, and it's important to copyright owners that they make sure that third parties aren't using their work and making money from it. So it's also important to do searches occasionally on your content and see if there's any copyright infringement. And my traditional method of approaching it is if I notice a copyright infringement, I find the owner of the site and I send them a letter and say, please take down this content. For multiple reasons, you don't want people using your content. Most commonly, it's third-party attribution of something you've written, but also there's SEO value to your original content, driving customers and people to your site. So if third parties are using your SEO content and driving people to their site, then it's inherently causing damage, and the benefit of the content is not benefiting you as the owner or originator, copyright holder. So now taking a look at 3 ways to use copyrights. One, when you create a copyright, this is just a little bit more academic, so I'll go through it quickly, but copyright ownership exists and you have the right to copy and to distribute it and to create derivative works such as books or movies from it. People can use your copyrighted content for fair use, meaning they do commentary or parody, or for educational use is often deemed to be fair use. And then you can look at the right side here. I apologize. And so use of copyrighted works can exist also on a separate level, and so that's this column over here. Moving on to the benefits of copyright registration, it's important to look at why someone would want to register their copyright. And I started kind of originally mentioning that you want to create a public record of your work, and ultimately that you may sue for copyright infringement if a third party is using it. Also, a registration provides you what's called a legal term as prima facie evidence. It's that it existed, you filed the copyright application, and now you're entitled to seek statutory damages, which are damages that exist in the statutes and say for every infringement that occurs, you get to get this much money, and you've had this amount of damages from it. And it also protects against the importation of infringing copies from other countries or other jurisdictions. So now quickly looking at what is a trade secret. And a trade secret is really not the same as a trademark or a copyright. Excuse me. A trade secret is a formula, and it's an internal documentation or process or design that's used by a business that makes it unique for that business, so that if a competitor were to come in and learn what you're doing, they could actually recreate it. What happens is sometimes you create a system or a profile or a mechanism. Very famous trade secrets include the Coca-Cola method by which they create the soda. But there are many other trade secrets. Customer lists can be comprised of trade secrets, things that are not generally known to the public. The only way actually to protect a trade secret is to not disclose it. So curiously, while you put trademark notices on file for your trademarks and you file a copyright for your copyright, you do not do the same thing for a trade secret. A trade secret you want to not disclose, and you want to make every effort to make sure that your employees and even your customers to some extent know that these are your trade secrets and that they cannot be disclosed. It's also important often when working with partners when certain information with a partner may become known. So for example, my corporation works with Intuit, and we exchange information relative to our business practices that if known by a third party would hurt either of our businesses. And so when we enter into an agreement, we have a non-disclosure in place, and it includes, among other things, exposure to our internal trade secrets and non-disclosure of those trade secrets. So I think that's an overall summary of trademarks and copyrights and trade secrets as it relates to someone entering into a business. But I'm 100% open to hear all of your questions that you may have about your particular business and to try to help you think through what's the right process for protecting your intellectual property. I think Hannah might be managing the process of the chat if you have any questions. Please feel free to type them in the chat box here in the right corner.
Yes, thank you. We'll give everyone a few minutes to send their questions in. As they come in, I'll read them to Deborah, and she can answer them for you. So as you just mentioned, if you have a question, just type it into the question box on your control panel and send them in.
In the meantime, I can share some information about how to give notice for copyright similar to that information I gave for trademarks, if it's helpful. When people create content for a website or they write an article or they're claiming content ownership for their copyrighted work, you do not also have to, similar to giving notice on the trademark where you put the TM, you can actually just give notice by putting a C with a circle around it and the year in which the copyrighted work was created. You don't actually have to have a copyright registration or a copyright even on file with the Copyright Office to give notice that you're claiming rights to that. In fact, it's one of the smartest things to do is to put both a TM notice and to do the C with the circle around it when you're initiating your work. So I think those are important tips for business owners to be aware of as they're taking off and starting their businesses and getting ready with trademark filings and their content for their copyrights.
Great tips. Thank you. We have first question is, does filing a trademark give you any coverage internationally?
In the U.S. Patent and Trademark Office, the active filing gives you national coverage only, but there are international treaties that are in place that give you rights to file internationally within 1 year of your U.S.-based filing. So it's important that if you intend to do international filing and you want to base it on your U.S. filing and the acceptance and registration of your filing in the U.S., that you pay attention to that 1 year deadline to get a presumption throughout other jurisdictions. There is a filing that can be done across many countries at one time, but the risk that you play with filing in a multi-level filing with an international filing is that not all of those jurisdictions will give you the registration. So many companies say, well, I'm just doing business in the U.S. and Canada and in England. And so they file in just those 3 jurisdictions rather than doing a global filing that includes more than 17 countries and realizing that one of those 17 disallows it, meaning you don't get them in any of the countries. So you have to look at kind of your expansion plans and what you're expecting to expand into and make sure that your applications on an international level really relate to your plans. It's also not inexpensive to file an international trademark. So it's important that you're attentive to, I really don't plan on expanding into China, for example, or that is my only country that I plan on expanding to, and making sure that you pay attention to those countries that you expect to expand into or are already existing in, and whose trademark rights are important to you. The other feature to pay attention to with that is that you also have to monitor your international trademarks. And so it's important that you are aware of the requirements for ongoing monitoring and filing and maintenance in those countries, and that obviously the benefits outweigh the costs associated with that. Good question.
Thank you. Here's another. How long is a reasonable time to expect trademark applications to be reviewed and approved?
Awesome question. So usually it takes 3 to 4 months to hear back from the initial communication from the examiner. It's actually getting faster now that so much of it is done online. It's the uspto.gov is the website. And so a lot of communication is via email, which has exponentially improved the process. So what happens is then they'll send you an email traditionally with the examiner response in it, and you have then 6 months to reply. Traditionally, people wait a while to reply, but there is no reason in my mind that you shouldn't reply right away with your response. Usually examiners are quite helpful on a communicative level. You can email them and say, here's my issue or my concern. A lot of people go to lawyers at that point. But I would say if you respond quickly, the examiner usually can be providing you with an answer within 6 to 9 months. There are hiccup scenarios where, for example, you publish your mark as part of the process that I mentioned earlier, and someone actually files an opposition. And an opposition proceeding then ensues where the opposer says, I'm not willing to, or I think this mark is infringing on my trademark, or whatever the case may be. And so with that, it will take a lot longer. But if your mark is smooth sailing, if the examiner has no issues with it at all, you can expect to hear back, receive a publication notice within 4 months. But if there are issues, then it's often on the trademark owner to respond quickly and get the action dealt with expeditiously.
Wonderful. Is there an approximate range of cost for trademarking your name?
Sure. So there are different options. You can do self-help and go directly to the U.S. Patent and Trademark Office site and try to file online, and usually the fees are associated with which classes you choose. So many times a new trademark owner will only file in one class. A good example is if you're opening a beauty store, you try to find the most broad international class to file in. It's called an international class because it's agreed to by multiple countries, and there are a number of classes that you can choose from, just over 40, and you basically say, my business falls into this class, and you pay on a per-class basis of $325. So many times smaller businesses just file in one class and get their registration and then expand over time. You can also go to a service like ours, for example. My corporation does it, and we actually do the filing for you and get it on file, and it's $99 plus whatever international class you file in. And then there's the legal option, going straight to a lawyer, and the range tends to be between $2,500 and about $5,000 per trademark. And that traditionally is just for the application. Then if you have to deal with a trademark examiner issue, then you pay more, obviously, for an attorney. And I guess you can look at it in two different ways. If you're not using an attorney at the outset, you may actually be presented with risks down the road, but many trademarks fly right through the trademark process, and they're not at issue, and so you don't have any complications. And so sometimes people say, well, I don't really need to hire an attorney in order to do that for me. I feel confident that I can do the filing on my own, and if something were to come up that was complex, then I could hire them down the road when the business is, has been in business for longer.
Great, thank you. We have another question that is a follow-up from one of our past questions. It was about how long it takes for the trademark filing to go through. The question was, is that 1 year from filing or final registration?
Yes, from filing, traditionally from filing. It's not from final registration, because once you own the trademark, then it remains in existence for 5 years, and then at the 5-year point, you have to file a statement of use, it's called, and it's basically giving the U.S. Patent Trademark Office notice that you're continuing to use the trademark in commerce. So if you file on January 1st, 2013, you could expect to hear back anywhere from June to September-ish, and maybe before, from the examiner giving you the authority to go ahead, that the mark is going to be published, and then you wait 30 days during publication, and then you get your registration certificate in the mail. So usually it's 1 year from filing that you get the registration, and then 5 years from your registration date you have to give notice of renewal.
Thank you. That was good clarification. Another question. What about copyrights or material created in a foreign country?
So it depends if a lot has to do with the author, and whether if the work was created by the author and you happened to be in a foreign country, but the author lives and is based and works out of the U.S., then it can be a U.S.-based copyright. If it's a foreign author, then generally with the U.S. Copyright Office, you're claiming some sort of existence within the U.S. When you're filing a copyright in the U.S., if that makes sense. So international laws have lots of different copyright rules, and there's tons of issues, as I'm sure everyone is aware, when you have copyright ownership with fraudulent copies of things being created internationally and multiple issues. The laws are so different. There aren't international treaties for copyright similar to those that exist for trademarks. So there is piracy and other issues relating to international copyrights that do come up. So I hope I'm answering that question based on kind of what you were looking for, but please feel free to clarify if I didn't.
Thank you. And that looks like it's all the questions you have right now. Feel free to, if you have any last-minute questions you'd like to send in, feel free to type them in. Otherwise, with that, we will conclude the presentation. I'd like to thank everyone for joining us today, and I'd like to give special thanks to Deborah for a great presentation and a lot of good information.
It's my pleasure. Thanks so much for having me, everybody.
A recording of this webinar will be available online at www.mbawomen.org/webinar-recording. This will conclude today's program. Thank you. You may now, one more question came in before I close out. Deborah, if people have follow-up questions, is there any way they can send questions to you?
Sure. My email address is dsweeney, DSWEENEY, @mycorporation.com. And the other thing I think that might be helpful is on our website, My Corporation, there's a center called Learning Center, and we have a lot of information about trademarks, copyrights, trade secrets, and what needs to be done and the specific requirements that might just be helpful or informational reading for the attendees.
Perfect. Thank you so much.
My pleasure.
And now with that, we'll wrap up the presentation. Thank you, everyone. Thank you again, Deborah. You may now disconnect.